You could also argue that the plaintiff is discriminating against the defendant on an unlawful basis. Additional defenses that are set forth in the RLTO I already discussed, some including cure. Another interesting defense, because it highlights conflict between the RLTO and the state statute, is that after passage of the time period set forth in the notice demanding unpaid rent, the tenant paid the plaintiff all the rent owed. Now, this provision of the RLTO conflicts with and supersedes the last paragraph of Section 209 of the Forcible Act. What the Forcible Act says is, look, if the tenant owes you rent, you just have to give them notice that they have 5 days to pay you the rent owed, and if they don't, you can terminate the tenancy. Furthermore, if they don't pay within that 5-day period, you can bring the forcible action, and you can accept, after you bring the eviction action, the rent that you demanded in the notice, and that's fine. The RLTO says, no, it's not fine. If you accept, after the termination notice expires, all the rent that was due that you demanded in the termination notice, you've waived your right to evict the tenant for that violation. You can also argue that the rent demanded represents an amount that the tenant used to pay for the repair of a minor defect, or withheld after the landlord refused to make necessary repairs, or that she used to pay for an essential service the landlord should have provided, used it to pay for substitute housing after the landlord failed to provide an essential service for which the landlord was responsible. It's very, very important that if you're going to present these defenses, that you make sure that the tenant complied with the notice procedures that are set forth in the ordinance and that Dave Morris went over. Since I just have a couple more minutes, I want to talk a little bit about what happens after judgment. Should the tenant lose, the court will enter a judgment for possession against the tenant, and maybe also a money judgment for unpaid rent. If the tenancy or the dwelling unit is governed by the RLTO, the landlord will not be able to recover attorney's fees. You can get attorney's fees for bringing an action that arises under the RLTO, okay, if you prevail on that action. But there's one exception to that rule, and that's if you're the prevailing plaintiff in a forcible action. You can't get attorney's fees for prevailing in a forcible action. You can get court costs, though. So the judge will enter a judgment for possession. The judge will typically stay enforcement of the judgment for a period of time, 7, 14, 21 days, based on the circumstances of the case. And during that period, the sheriff cannot go out to enforce the judgment for possession. Once the stay period expires, the landlord can pay the sheriff to go out, and the sheriff can go out and forcibly evict the tenant, or, as I said, the rules have now changed the locks on the unit. Now, there are post-judgment motions. The most common one you'll see is a plaintiff's motion to enforce a judgment that has expired. The landlord usually just has 90 days to enforce the judgment for possession. And if they don't enforce the judgment within those 90 days, they have to come in on motion pursuant to Section 107 of the Forcible Act and ask the court for an extension of time within which to enforce the judgment for possession. And the courts will routinely grant these motions unless the defendant establishes that the tenancy has been reinstated. And the tenant can usually establish that if the landlord has really waited 90 days, because very often what the landlord will have done is accepted rent for some period after obtaining the judgment for possession. Now, if the landlord also got a money judgment, well, obviously the landlord can accept the money judgment, allow the tenant to satisfy that money judgment, and still enforce the judgment for possession. But if they accept some amount over and above the money judgment, they've reinstated the tenancy, and they should not be allowed to enforce the judgment that they obtained. You can argue, the tenant can argue that the breach upon which the judgment was issued has been waived or cured, that the parties entered into a post-judgment agreement, and that she's performed her obligations under this agreement, or that there are other legal or equitable grounds that exist that bar enforcement of the judgment for possession. Don't ever forget equity. You can't often use it, but equity is sometimes a very, very effective tool if your client does not have a valid legal defense. They may have a valid equitable defense. And essentially what equity says is, look, even if the plaintiff has done everything right that it's supposed to, even if it's legally entitled to the relief it's requesting, it would, because of the circumstances, because of the special circumstances of this case, it would be manifestly unfair, or would shock the conscience to allow them to obtain the relief to which they're legally entitled. Finally, I want to mention that there's a provision you should be aware of. It's 735 ILCS 5/12-183G. It's in the materials. It allows the tenant to petition the court to vacate a judgment for possession if, after entry of the judgment, the plaintiff has by some act reinstated the tenancy. You'd be surprised how often I'm able to rely on this provision. So I think that's all my time. Thank you.
Thank you, Larry. By the way, I still think you're a young attorney.
Okay.
We now have a few minutes for questions and answers. People have questions for the speakers.